In an effort to keep in mind the speakers' tight schedules and keep things running on time, I'd like to start this panel. And really, this is a continuation of the panel we had earlier. Earlier, we talked about legal tech and liability, and now I'd like to continue that conversation and talk about another kind of first-year required class. So the last one was torts. Now we have legislation and regulation. Professor Stevenson teaches that class, and I'll let him take it from here. Thank you so much.
Sure. So thank you very much. Thank you for the introduction, for organizing this panel. As Robert just said, my name is Matthew Stevenson. I'm a professor on the Harvard Law School faculty. I know very little about technology. I typically don't even notice it unless it stops working, and then I desperately try to contact someone who can figure out how to fix it. But I do know a fair amount about the legislation regulation first-year course that we have here at Harvard Law School and the topics that are covered there. So my role in this panel is simply to moderate. So I will turn it over in just a moment to our two experts, and then after each of them has had an opportunity to introduce themselves and make a preliminary presentation on the order of 10 to 12 minutes, 15 minutes max, I'll try to kick off the conversation by asking a few questions from my perspective as a teacher of the subject about what their technological insights might add, and then we will open it up for more general discussion. So that's how we're going to proceed. And now let me turn it over to our esteemed panelists.
Sure. Hi, good morning. So I had a chance to meet many of you yesterday. I'll reintroduce myself for those who are attending today for the first time. My name is Colin Lee. My role is with a company called VLEX. It's a legal publisher, operates globally. Harvard University subscribes to VLEX for researching global regulations and legislation, as well as case law and so on. My background on this topic actually extends pretty much back to law school and then shortly thereafter. I began most of my legal career, or I began and spent most of my legal career working as a regulatory lawyer in the telecommunications industry. So it's an area that has its own body of law, its own set of rules, its own set of practices, not only unique to the domain, but unique to the way that you look for the information. When we talk about legal tech, which I managed to get exposure to at other stages throughout my my career, operating a not-for-profit legal publisher in Canada called CanLE, Canadian Legal Information Institute, and now my work with VLEX. You begin to look at this body of information and say, surely it shouldn't be this complex. Surely there's a better way. So I think today we're going to be going in and out of a lot of the elements. So I wanted to start off with a little bit of foundational understanding of legislation and regulation, not from the perspective of how we see it on Lexis and Westlaw or how we experience it in school, but how it's experienced in real life. So there's a few issues. I'm not going to turn around, maybe I will a little bit. In the case of what's available online, there is no perfect set of information, no perfect resource to gather this for the general public. When I give an example of an availability issue, I mean, sometimes we're literally talking about it is simply not accessible online. Before I go through the rest, I'm actually going to use two small examples. One that the co-founder of the Legal Information Institute in Cornell, the recently retired Tom Bruce, liked to use, and then one slightly longer one that's a personal story. And it goes to questions of availability. So Tom was often fond of using the example of, so you want to open a dry cleaner. Where do you find the rules on how to open a dry cleaner? So the Lee looked for information. They found that there were 27 different sources that you had to go to figure out all the rules that were associated with your business license, managing chemicals, employment, and on and on and on. So even if you could find some of them, there was often an availability gap to all of them. So one of my personal experiences is one that's going to be a little bit more familiar to some of you. So I got a parking ticket. And being a lawyer, I wanted to fight it. So I parked in a school bus loading zone. Now, I happened to do this at 8 p.m. at night in the dead of winter. Got a ticket. So I went digging around to find the local bylaw that governed that. The online version of the bylaw had a notice, this is not official. So there was a status problem. There was an indication what was there. There was also a currency problem. Was I looking at the most recent version? And a few of the other problems that you see up there were also part of that experience. So I found eventually something that said the official versions are only available at the Central Public Library or at City Hall, in the archives of City Hall. And there was a reference in the bylaw to a subordinate piece of regulation that dictated which streets the school bus loading zone rules could apply to. Now, those weren't online, so I went to the library. That was the closer place. Well, the library only had physical copies, so we had a format problem. I think I have that up there, a format problem to access it. So I flipped through the books, and I found essentially the same reference that I had, but now I'm looking at a book in the library that's the dedicated, according to the city I live in, the only official source, or the only thing that can be counted on as official. And that was out of date. Again, I had the currency problem. I also had an interconnectedness problem, because the things that it would reference, it couldn't lead me to. So I said, well, I guess I'll go to the archives. So I trundled down the street over to the archives. I walk into this giant building that was completely empty. I walk down this long, darkened hallway, and I get to the security desk. And they say, who are you and what are you doing here? I said, I'm here to view the city archives to look at the bylaw. And they said, yeah, that shut down 6 months ago and moved to the other end of town. So again, communication problems, access problems, and so on. So undaunted and not wanting to pay the $75 fine, I eventually found my way to the new location of the city archives, where after signing in, giving my ID and so on, so I had an accessibility issue, I was allowed to enter the room where the underlying subordinate regulations were kept. And lo and behold, there was a reference to something from 2003 that dictated the particular elements of the parking bylaw that listed a series of streets that it applied to. My street wasn't on there, so I thought, hurrah, I've got it all figured out. But of course, there was something else somewhere else that referred to a sign bylaw. And wanting to make sure that I was covering all my bases, I went digging into that. I had to go into the minutes of the city council meeting to find out that although there had been no update around the time of my ticket, there was an update due to come into effect a little bit later that changed the rules a little bit, sort of allowed the city to stop relying on relying on having to list each individual street where this thing would apply. It was deemed to be accepted that when a sign went up. But that wasn't going to come into effect until a little bit later. So I shared my story with a few senior lawyers in my jurisdiction, including the then president of the Canadian Bar Association. They said, you have to fight this. This is an open law. This is an access to justice question. And so I took it upon myself to say, yes, I'm going to do something good for the people. I'm going to say that this is important. We have to go about it. We have to go about getting this. And I mean, this was my day job. At the time, I was the CEO of the Canadian Legal Information Institute. We had all federal legislation and provincial legislation and regulations. I say all, but there was also a completeness gap, even in our own thing, in that we had all public statutes, but not all private statutes, which are a whole other area. But so I decided, I had to go ahead and fight it. So finally my day comes, I get to court, police officer didn't show up, so they threw out the ticket and I never got to argue it. So I go home, my wife said, well, isn't that good? And luckily my daughter understood, no, you wanted to go in for a fight, you were ready to go. But the thing is, this is just sort of a minor inconvenience, but in terms of the parking ticket, but a major inconvenience in terms of accessing the law. And so all of the things that we want to do with legal tech are stymied by the fact that even if we can find some pieces of the law, we can never find all of it. And so I want to give a shout out to, here's the problems with law. I forgot about that slide. So now I want to give a shout out to someone named Sarah Glassmeyer. And so Sarah Glassmeyer was here a few years ago as a one-year fellowship, and she did a research into the openness of primary law, case law, codes, and regulations. And I want to share some of her findings, because although they're dated to 2014, I think most of them are still relevant today. And again, it goes to understanding the scope the challenge before we get into tech. So I'm not going to read through all of them, but just going to highlight a couple here. So one of the most important things I want to highlight are the first two. The idea of official versions of what's online. So when you see something online, can you actually rely on it as a statement of law? And 6% of the states that put their state codes online say, yes, you can rely on this as an official statement of the law. So what about the other 94, so the other 47 states? What reliance can you put on that? And then you'll notice there's a strong correlation between official and PDF, both in terms of codes and regulations. And that goes to an accessibility issue. So a jurisdiction is more likely to declare their online version as official if it's in PDF and essentially relatively inaccessible. So if they put something up in HTML or XML or have an API for pulling it down, it's a lot easier to work with, but it's, from the perspective of people who issue primary law, and I would include courts in this, there's always this fear, well, what if somebody modifies it? What if somebody dares represent it slightly differently, so they try and lock it up in a PDF to make it that much harder? So a significant portion of like the work in legal tech in terms of opening up access to legislation and regulation in the US in the past 10 years, and most of it in the early 2010s, was about unlocking PDFs.
So I just in case the room doesn't know this, you can absolutely modify PDFs. So just like as lawyers, like just so you like, if you don't perpetuate this, let's end this
Yes.
now. PDFs are just as modifiable as other documents. All right, continue. Sorry.
Yeah, no, absolutely. Absolutely. And then at the bottom of this, I referenced bulk access. So again, bulk access is incredibly important because now we're talking about the difference between the individual like me who needs retail access to information or Tom's dry cleaner who needs access to a retail level of information in order to exercise their rights, into the developers, the wholesalers, the publishers, and so on, who want to consolidate this, the law firms who want to develop an understanding of these things. Likewise, disclaimers on correctness, so even if they would have it as official, they would say, just because we put it up and we called it official, we want you to know that we're still not saying it's accurate. We're not going to be held responsible for what's up there. And then, advanced search. Essentially, there's a whole whack of problems in getting access to this. So, but in the meantime, risk and compliance is a major part of business activity. It's a major interest of law firms. It's in terms of market cap, I think it's greater than legal research generally. This is an area that affects everybody, and not just at state and federal levels, but at municipal levels in a major, major way. And so there's an incredible amount of innovation that's happening around small groups that are trying to do something with the pieces that they can get a hold of. So one example that I'll reference, there's a group out of, I think they're split between Colorado and California, called CannaRegs. And so CannaRegs is focused on ensuring that everything that you could possibly need to know about regulation of cannabis within a particular jurisdiction is known. And what they've discovered is that most of that action is at the municipal level, and most of the interest in the content is among lobbyists and property developers. Because knowing when the rules are about to change is more important to those groups than knowing what the rules are. Thanks. There's a whole lot of other projects that are underway to do stuff like this. And I just want to cite a few more. And I'm not going to go into a huge amount of detail on these, but just to give you a sense that notwithstanding the barriers that people face, it's slightly easier in some jurisdictions, but still not all the way. So in Europe, for example, there's a website you can go to called Eurolex, and you can get access to a lot of this content through APIs. So you can pull down this information and work with it. In Canada, at the federal level, all of the content is available in XML, HTML, and PDF. And the entirety of, for several years, of the federal level regulations have been declared official. But that doesn't help you, again, if you're the dry cleaner who has to comply with multiple levels. So if the province you live in Canada, or the city doesn't have that, you're still falling short of what's available. So there are groups. There's a group called Codify in Canada that has sort of taken it upon itself to keep track of all the updates of all statutes and provincial and federal at all levels and all regulations, all bills going through the provincial legislatures in order to give update services. And they began doing this commercially and doing special projects, but the person who runs it, a guy named Paolo Tonelli, has said, no, this is more important than me making a few bucks. This is a guy who's already had a successful commercial exit in another business. So he's turned around and started making all of this for free. So through his site, you can get all of this stuff for free. And he's going further. He's saying, I want to do more than what I'm doing just in Canada. I want to make Canada better. I want to help with the US. I want to help with the UK. Like this is now, he's going completely mission-driven on this. On the flip side, you have a lot of users of this information trying to figure their way out to how to solve their problems. And part of what we're going to be touching on, I think, throughout this session is the rule making in this kind of environment. And so as an example of that, the Government of Canada put out an RFP for what they call their regulatory evaluation platform. So this was on behalf of 10 regulation-making federal government departments, agriculture and, I think justice was in there and a handful of others. And what they wanted to be able to do was have a tool that would allow them to evaluate the effectiveness of prior regulation by comparison to existing regulation or proposed regulation. So they put out an RFP and they said, we want people to be able to do this at the federal level and at the provincial level and optionally bring in US and EU. So I wrote them because we were a qualified bidder on this. And I said, none of us can actually get the provincial. Like this is actually, you've included something that's impossible. So even the government is completely unaware of the limitations. And the very last thing I'll mention on this is that, again, I mentioned at the beginning, we are a legal publisher. As a legal publisher, we operate in multiple jurisdictions. So we deal with this in different levels. Where we have really good machine-readable access to information, we do super cool things. So you're looking at any reference to a statute or regulation in any document, and we'll show you the timeline of, this document is dated January 4th, 2001. This section of the thing was modified then. Here's the section, here's the diff between the two, and on and on and on. And so this is what I think a lot of us want to be able to do, but I wanted to sort of start us off with an understanding of where we are now. Thanks.
Hey everyone, I'm Dave. I currently work with a private equity firm, but the reason that I'm here is because of the work that I did in my previous roles. So I'll start with a little bit about why I ended up here. And incidentally, it wasn't a parking ticket. It was related to bike laws. So at the time, I was the general counsel for the Council of the District of Columbia, which is the legislature in DC. And there was a software engineer for a company called Mapbox who wanted a copy of the law that applied to bikes. And it turned out I was the person responsible for publishing the law related to bikes. And so I told them to go to the library, which is what you would tell any person. If you want to find a law, you go to the library or go to our web portal where you could go and get it. Turned out he said, well, I want a copy of the law. And I was like, again, you can go to the library and you can go pull it from the shelf, or you can go to our website. And it took me a while and a denied FOIA request to understand that what he really was getting after was the underlying data behind the law. And it turned out that we had a contract with a legal publisher at the time. It was West, and then shifted over to Lexis. But we were publishing through these legal publishers the official law of the District of Columbia, but it was not made available in sort of a bulk data format. So you actually had some of the things that you saw up there. There was a copyright claim that the District of Columbia claimed copyright. There was an accessibility thing, which is that we published. To the extent that we published, it was online. But he wanted something very specific, which is that he wanted to blog about this, and he wanted to have a permanent URL that he could point, to say here's the bike law. And it turned out we couldn't make that available in the District of Columbia. Fast forward several years and sort of personal journey and a lot of different things, and now happy to say like the laws of the District of Columbia are available online and available for bulk data download. And so the law in DC is like now presented as data. Yay, big win. But why does this matter? And I kind of want to take a step back. The thing that's interesting about legal data and law as data is that there's actually a relatively rich history in the United States about legal publishing and the changes of technology and how they affect the practice of law. So I was reading an article published in 1909 talking about this really crazy problem of typewriters. Typewriters really screwed up the practice of law because now all of these courts were publishing opinions, and like now there were all these newspapers that were publishing and like news periodicals that were publishing all this latest stuff, and they were literally filling shelves. They couldn't keep it, they couldn't fill the shelves. They didn't have enough shelves to fill to handle all the new articles that were coming out. And so this guy came up with this concept of like the digest and the head note, right? So like the state of the art for lawyers for many decades was like, oh, they were going to use these head notes, and that's how they're going to manage the digest. So they would keep up with the changes in the law through these head notes. That led to litigation involving, sort of the copyrightability of these head notes and sort of and the like. So then you fast forward into the 70s when all of a sudden databases become really available. And oh man, now you're no longer dealing with newspapers, but you have databases. And so you have this Boolean search that you can do in Lexis and West. And now associates, are, dealing with the most advanced search that you're dealing with in terms of, because these databases allow for text search. Again, you sort of have this weird thing where you now have litigation around it because next year at the Supreme Court, the most exciting case on the docket. It's not DACA, it's not discrimination. No, it's Georgia against the PRO, the Georgia against the public.resource.org, which is about the copyrightability of annotations in state statutes. Take a step back for a moment. These are official laws published by the state of Georgia. The state of Georgia claims a copyright on the annotated version of these state statutes. And the reason that that's important is because in 2019, we are still having statutes that are claims with copyright and restrictions in the use, which makes search that are not in sort of official authorized areas to be restricted. And so who knows what will happen? That's why it goes to the Supreme Court. We'll see what happens, whether the public edicts doctrine will extend to annotated state laws. But the point is, like, even these basic questions about access to law are still being litigated around basic primary legal materials. But then you start to say, okay, well, gosh, typewriters are a real big game changer for the practice of law for lawyers. Databases were a big change for the practice of law. Picking up on what Kat was saying earlier today, like I think AI and NL and NLP and ML are probably going to have a pretty big impact. I don't know how it's going to affect the practice of law, but it's pretty certain that it will, because predictive analytics is almost certainly going to affect how lawyers practice the day job of just finding what the law is. Fine. So that's a little bit about one part of the legislation and regulation about how this will affect the law. But I want to shift actually to the executive side. So after leaving the DC Council, I had the opportunity to join the federal government in an organization called 18F. And there at 18F, we spent a lot of our time focusing on e-rulemaking and picking up on how do you have official sources of data, of legal materials that are published as data. And so picking up actually on the CFPB was sort of path-breaking in terms of publishing the regulations as data. We started working on this project called the e-regulations platform, which would show data as, you could see, here's the regulation, here's the Federal Register notice, here's the change that we made as a result of that Federal Register notice, here's the CFR sort of in context. You can even see interpretive opinions in context, and sort of you can start to map that out. And it was a really fascinating experience, but one of the challenges was actually just creating the e-regulations as data, because again, we're still, it's at this point 2019, but at the time, even the federal regulations aren't published as data; they're published as HTML, which is nice. And the GPO publishes it in PDFs because PDFs are super secure and not malleable in any way. That's not true. Although they do actually, to their credit, they do have a digital signature process, which is different and actually is a form of authentication. But suffice to say that there's been work that had been going on with e-rulemaking. But what's really been fascinating, and hopefully we can touch on this a little bit as well, is that now that you have things like public comments, notice and comment periods, people are submitting lots and lots of comments because it turns out people have a lot of things to say. And recently, there was some interesting work around notice and comment for the FCC, I believe, and having hundreds of thousands of comments and using AI and machine learning to actually like aggregate some of the notice and comment comments into clusters so that you could review these many comments and actually understand the different goals of the commenters without having to actually manually review them. So it's interesting to think about like an e-discovery future for notice and comment. What does that look like? But then I wanted to sort of take more of a theoretical step back and start to make an argument. And I'm not sure that this argument will hold, but I'm going to try to make it anyway, and hopefully you can poke holes at it because you all are law students and lawyers. Is to make the argument that I think that as legal materials become more widely available, our actual understanding of what the law is will shift. I don't know a great deal about constitutional theory, but one of the things that I've come to understand is this idea of originalism has come into vogue in various ways. But one of the things that makes originalism viable as a argument is the ability to access the corpus of original writings, right? If you can't actually go and get the written words of what the contemporaneous thinking was, you can't reason about originalism. Well, as we start to think about legal texts, as legal texts become more available, as things like regulations and bylaws or administrative decisions, administrative enforcement becomes actually widely available, how far is it to say, well, maybe drafters of legislation should be aware of the contemporaneous decisions of administrative agencies? Right now, we sort of say, well, you know, they maybe knew about this decision, but maybe not. But as natural language processing becomes more widely available, things like term of art and whether something is a term of art is actually a knowable thing, or at least a probabilistically knowable thing. You could say, well, given the fact that in these trade papers, this term pops up, this bigram or trigram or n-gram pops up many times, we might be able to say, well, yeah, that we can show probabilistically that is a term of art as opposed to something else. So thinking about how even corpus selection might affect our future statutory and regulatory interpretation. The other thing too is really around I think due process may inform some of this as well. So we think about parking tickets. I've been thinking a lot about in the last couple of weeks because I had to pay $100 for it, a speeding ticket, and it was from an automated traffic camera. And an automated traffic camera, like there's not much you can do about that. Like, how do you contest it? It's from a camera. It caught me on camera. I was speeding. And so like what I could do is I could say, well, it was calibrated properly. Well, okay. How would I know that? Well, it comes from the sensor. Okay. But what are the types of arguments that I can make? Well, was there good visibility? Was I a certain distance from the camera? But you can imagine that the concepts of what we think of as substantive and even procedural due process may shift as we start to get to more automated regulations and automated enforcement mechanisms. And so I think that one of the sort of the interesting and exciting areas of legal practice is going to be thinking about how does the advent of law as data change both the actual practice for lawyers. So when you're trying to search for the law or know what the law is, that is going to change for you all as a result of these data sets becoming more widely available. But then also in terms of substantive practice of law, how do we understand how to make arguments is going to change as these legal materials become more widely available. So with that, I'll pause and take questions.
Great, thank you both of you. That's really interesting. And again, this is, although I spend a lot of time thinking about legislation and regulation, I don't spend that much time thinking about technology. So for me as a teacher of the subject to first-year law students, it's actually really helpful to think about the legal world that you all will inhabit may look different from the one that I inhabited, and very helpful for thinking about how I present this material to my students. With that, there are a few just observations I would make, and then maybe some questions I'd like to put to you guys, and then I hope we'll be able to involve everyone else in the audience as well. And let me set it up this way. So much of what both of you talked about, Colin, you especially, but Dave as well, has to do with accessibility. of the law? Like, can we actually get the material? And that strikes me as an extraordinarily practically important problem, which it's great that you and others are working on. Not that much of a conceptually interesting problem. Like, you need to have, before we can start arguing about what does this statute mean or was this regulation properly promulgated, we need to get a hold of it. And if there are jurisdictions where you can't do that, or you have this Kafkaesque story about trying to figure out what the rules were for parking in a bus zone, then everything's sort of cut off from the beginning. And this is not an issue that I think a lot about, at least in my class, because I'm typically teaching like federal statutes and administrative regulations, and whether this stuff is available like as data, and you all will have to explain to me what the difference is. Like, it's there. Like, there's never really an issue in a case involving interpretation of a federal statute that we just don't know what it says, right? Or with a federal rulemaking that we just have no idea what the notice of proposed rulemaking looked like and what the comments were and what the final rule. That's all accessible. So I'm really interested in asking you guys to develop a little bit further something both of you touched on, which is that assuming that the material is available, so assuming that your projects and others succeed, or assuming that we're talking about something like the US federal government where accessibility of the legal materials isn't really the principal challenge, what do we do with this? And in what way do modern technological developments allow us to do things that are different? And Dave, I think you put this really, really well. It's not, obviously this affects the practice of law, right? If you, Westlaw and Lexis were hugely important because it just saves a ton of time, right? I think I might have been the last 1L class where we had to learn how to so-called shepherdize cases. And probably those of you under 40 don't even know what that means. But like, that was the way you would do it, and now it's not anymore, and that's great, and makes everything faster, and that's wonderful, but like, it didn't fundamentally change the way people argued about statutory meaning or talked about the right way to think about administrative regulation. It just like made things faster and better, so great. But on the substance, what could the technologies do that would, in some more fundamental way, affect the nature of the enterprise as practiced by lawyers or by government agencies, as opposed to just making it kind of, I shouldn't say just, I don't want to minimize it, as opposed to making it easier, more convenient, more efficient, et cetera. Both of you, I think, touched on aspects of this. There are two that maybe I want to highlight and really get some additional elaboration from both of you. And these are drawn right from my first year legislation and regulation class, and many of you in the room may have taken some version of it. Some of you, a few of you maybe with me, but others with others. So the first is arguments over the meaning of text. So I'll start with the legislation part and then turn to the regulation part. Arguments over the meaning of text. And there's a whole set of conundrums about the right way to determine what statutory texts mean when they're not clear. And these are debates that go back literally thousands of years, right? Aristotle was writing about this stuff, and this was true in other cultures as well. You know, the letter of the law versus the spirit of the law, and when are terms being used in a technical sense, and when they're used being in ordinary sense, and what source. So there's all of that cluster of material. So Dave, as you were suggesting, and I think, Colin, you alluded to this too right at the end of your talk in terms of what sorts of exciting things could we do if we actually knew what the regulations were. So how might that change the way we think about interpretation? So it's true, and Dave, you alluded to this, that we can now more effectively do a frequency analysis for how often different words or phrases are used. And there's this branch of statutory interpretation theory literature that refers to what we call corpus linguistics, where the simple version is like we do a Google search and how often it comes up, and then there are fancy ways to do it. But there's been some pushback on this in the scholarly literature that suggests, well, what exactly are we learning from this? How much does this actually help? So there's a word. It has, let's say, at least two different meanings, and we can see what their relative frequencies are. And let's say it's like 70-30. So what? We need to figure out what this term means in the context of this particular statute. So one question I would ask is, frequency analysis is sometimes useful. Like if someone asserts this word never means this thing, and you can show that actually there's a substantial population of cases where it does, super. Right. If it turns out that one usage is like 99.9% of the time, super useful. But in most cases of actual statutory ambiguity, the hard cases that lawyers encounter, it's not like that. There are two plausible interpretations. Everyone kind of understands they're at least within the realm of plausibility. Frequency analysis, I'm not convinced, does that much by itself. So what besides counts, what besides frequency analysis could more sophisticated tools than just doing a Google search and counting do, assuming we have all this material in terms of telling us what this means? So that's one cluster of questions. The second is that with respect to regulation, and again, Dave, I'll pick up on something you talked about with respect to the world of e-rulemaking. So again, as many of you know, especially if you've taken the first year legislation regulation class here, the basic default method for federal agencies, and actually most state agencies too, but I'll focus on the federal, to make binding regulations is the so-called notice and comment process, where you have to publish a notification of the agency has to say, this is what we're thinking about doing, and then they have to hold this open for a period of time where people are allowed to send in, like, here's what I think, and then the agency, if it promulgates a final regulation, has to explain why it did what it did, and that explanation pursuant to the way the courts have interpreted the relevant statutory provisions have to respond to, I think the way the court puts it, are material, non-duplicative comments. So the advent of so-called e-rulemaking allows, so now a lot of these notices of proposed rulemaking are not just in the published Federal Register, but they're online. You can go to regulations.gov and find like all of this stuff. And many agencies, I think by the default rule is now you can submit comments online, which results in some agencies, at least for big rulemakings, getting like thousands and thousands of comments, most of which are like 2 sentences long and don't mean very much. This used to be done by postcards. Now and I was really interested. This I hadn't heard of. The example of using AI algorithms or machine learning algorithms to help the agency process all that stuff seemed like one potential way that the technology could make a positive difference. And I want to invite both of you, if you would, to elaborate on other ways that the technology might, let's say, improve the notice and comment process with reference to the ends of that process, right? We don't just do this for our health. The reason that we do this is we have a certain belief that before an administrative agency issues rules that will bind the public with the force of law, they are obligated to allow potentially affected parties not only to know about it, but to make their case to the agency and obligate the agency to at least respond in some way. So how might the technology enhance our ability to pursue those ends? And are there concerns about whether certain uses of the technology may undermine those ends? So one of the reasons I was fascinated by the AI example is some people had suggested there was kind of a counterproductive result of making it so much easier to submit comments, which is the difficulty of submitting comments functions as a kind of screen, meaning that, you know, you only submit something if you really know about it and care about it, and once it's easy to just sort of spam the agency, it becomes harder to process. If you use these algorithms and the algorithms are sorting the comments, and maybe this is picking up on something I heard at the end of the last panel and I only caught the tail end, what if the algorithm kind of misses something? What if the agent said, like, the way we're going to try to determine if comments are material and non-duplicative is to run them through some algorithm, and some party wants to say, I submitted an important comment, and you just grouped it with a bunch of other comments, or you dismissed it all together and it missed something. So I'm sorry for going on for so long, but I'm really interested in better understanding how new legal technologies can not only improve accessibility, but if we get to the world that both of you want us to get to, where all relevant legal materials, legislative, regulatory, and others, are available as data in machine-readable format, what would happen then in a way for thinking about not just making lawyers' lives easier, but how might this in some fundamental way change the way we approach, the way we think about the legal issues that we need to resolve? So maybe I'll give each of you an opportunity to maybe say a little bit about that very general question, and then why don't we turn it over and allow you all to ask what are probably better and more informed questions. Whoever wants to take it first, go ahead.
Sure. Fair bit packed in there, but I'm made a lot of notes, right? Because I think I can pick up on a lot of these points. So I'm going to start towards the end. You know, assuming the perfect world of access to information, access to tools, and so on, what are the primary implications? I think it legitimately does change the way we argue, and it will change rulemaking. The shortest explanation for why is our existing process, regardless of whether it's like a notice of proposed rulemaking or, you know, participation, you know, in some other capacity to engage, is that it leads to this concept of looking where the light shines. And when you're sort of overwhelmed by a lot of information, sometimes where the light shines is the submissions from the people you know, the sort of the frequent flyers before the agency. A lot of administrative agencies are not necessarily prone to regulatory capture, but they're prone to reliance on industry to contribute a lot of their detailed understanding because they themselves are overwhelmed in a particular area. So what tech can do is that it stops the light from shining in certain places and broadens where the light shines. More information can come in, more can come forward. Related to that, it changes the like asymmetrical sort of arms race between public participants and industry participants. And I say this as a long-time industry participant. So I worked for a phone company as a regulatory lawyer, involved in a lot of regulatory process, and also for a year and a bit as a lobbyist. So I sort of know this from the inside as well as from the technology side. Because volume winds up reintroducing the concept of practical obscurity that open access and tools erase. Just volume can bring it back. And so this is a chance, again, to sort of bring some greater balance. Some of the things that the tools can do more specifically to illustrate what I'm saying that they can do generally and the impact that they'll have generally are to find relationships where the links themselves aren't immediately evident. So let's say, like from a simplistic approach, you're looking for repeated phrases, terms of art, or something like that. Well, there's also other ways of saying the same thing. So if I went up the hill, or I was going up the hill, I started at the bottom and now I'm at the top of the hill. However you could do it, the tools are better and better and better at finding those related items. And sometimes it's as simple as saying this phrase is like that phrase, this word is like that word. Other times it's looking at sort of the context of the whole document. So there's some tools that are coming to vogue in US legal research, initially started by a company called Casetext, and a tool called Kara, where you analyze a document and using what can be gleaned from that document, they find related information in the database. Now there's Ross. We have one, we call ours Vincent. These kinds of things are really great for finding relationships between material when the relationships aren't themselves direct. So again, in participation in public process around rulemaking, if I'm searching a document for reference to a particular thing, it may not be there, but there may be 6 other things in common in my submission with another submission. So this kind of information can be surfaced by looking for other related elements. So it could be at a semantic level where you're not even looking at the individual words and phrases, but you're doing sort of a mathematical similarity between documents. And so this kind of stuff is also really good for unearthing astroturfing, where the thousands of submissions that come in saying we absolutely have to do X are shown to be just mild variations of the same. This is all really helpful, and I mean ultimately it comes down to democratization of the ability of smaller and less frequent players to potentially have as significant an impact as the larger and more frequent players. These kinds of tools make it easier for the lawmakers themselves to understand the difference and be exposed to it. Makes it easier for the media to understand the difference and be exposed to it, because again, we all look for shortcuts. Either they're mental shortcuts or they're physical shortcuts, and so things help. So I'll give you one example, and unfortunately I can't name the institution, but we're working with an institution in Canada on precisely this topic, this idea of saying that they're an active participant in a particular set of regulatory processes. They are consistently at a disadvantage in terms of their ability to apply resources to the research effort. So they've got a grant that's going to essentially allow their students to become trained in defining an information architecture around the underlying data, and then we'll pull it into the tools that we use for everything else, and they're going to turn around and make it free for everybody. So these kinds of things can have a significant difference on how we practice, because I think we can't. Sorry, I'll just close with what I said at the beginning. Accessibility and tech removes practical obscurity, volume reintroduces it, and so tech has to beat it back again.
I think what I would add, and I think Colin captured most of what I was thinking, but the other nuance that I'd add is that one of the things that is not obvious to non-technologists, so it's important to make this explicit, is that most AI, NL, NLP, ML, and neural networks are actually probabilistic. They don't tell you definitively what something is. And so as I think about the ambiguity of text, it's actually shifting the weight from, well, how do we describe what's ambiguous to, well, what do we think is an appropriate trade-off with respect to the probability? Is a 70% accuracy rate enough? And frankly, I think that those are going to be really interesting litigated questions over the coming decades to say, is my algorithm to filter out non-similar comments or similar comments, is that algorithm accurate enough? Or am I depriving other folks of due process? Similarly, you mentioned corpus linguistics. I think a lot of the debate may shift to, do you have the right corpus? There's a significant difference between a Bloomberg article or a Politico article and a local sports section of a newspaper in terms of the types of words that are frequent and what words may mean within that particular context. And so as we're thinking about corpus selection, that will actually inform whether something is ambiguous or not. And so I think as we start to play out some of these scenarios, I don't necessarily think that the materials themselves are going to fundamentally alter the practice or the substantive content of law, although I think that as society becomes more familiar with the inherent ambiguities presented by these technologies, that lawyers are going to have to adapt their arguments accordingly. In other words, the idea of doing a Control-F word search 20 years ago, nobody does that. Now everybody does that. Everyone can use Google to search an entire body of knowledge, whereas 20 years ago that was inconceivable. And so that forces lawyers, it forces judges, it forces policymakers and regulators to change their expectations about what you can and can't do. Sort of again picking up on what Kat was getting at with regulators. Regulators could theoretically expect to investigate an entire company's communications. That would have been inconceivable 50 years ago. You can't know every conversation that happens, but it turns out you might be able to in a future state. That suggests that the relationship between regulators and those whom they're regulating may shift over time as well. And so I don't necessarily, I don't come with this particular prescription of what the future will look like. I'm actually not very good at forecasting, other than to say that what I have seen is that the practice has shifted as these materials have become more available, and our own understanding of what the law should look like shifts along with the technology.
Yeah. I just have one small thing to add to that. And just from the perspective of the lawmaker themselves and the degree to which they rely on these tools. So there's an effort in Canada to adopt what's called an algorithmic impact assessment. And so this is among any kind of federal government decision maker to determine the degree to which reliance on an algorithmic or robot process outcome is acceptable. So if it's booking campsites, no problem, let the machine do it. If it's something like the adoption or the extraction of particular information or the adoption of a rule and so on, there's new expectations that are required, new level of diligence that's required. So this has very recently been adopted by all federal government departments in Canada, but not by all administrative tribunals. There's a certain amount of, they're not quite judges, but there's still a certain amount of independence, akin to judicial independence that's accorded those groups. But I think this is also going to have an impact, not just on how the arguments come in, but on how the decision makers themselves will elect to rely on the math. And again, one other throwback to Sarah Glassmeyer, who has my favorite quote of all time on this, is that the judge can't argue the result is math, and the judges ain't got to do shit. Welcome to the law, son. So.
I feel like there's so many things I would love to follow up on, but I'm mindful of the time, and I want to make sure that we at least get one or two questions in before we close. If no one wants to say anything, again, I got about 6 things I want to ask about, maybe 60. But let's get some voices from the audience before we unfortunately have to wrap up. Yes, please.
So this conversation reminds me of something that went on in my family. So my husband's name, his official name is Robert, but we all call him Bob in my family. His family calls him Robert. So my sister ended up being his aunt's speech-language pathologist after she had a stroke. So she walks in to the room, the entire family's there, and she introduces herself, and actually she says, "Oh, we've actually met before. I was the maid of honor at Bob and Kelly's wedding."
Right.
His two cousins, his aunt and uncle, everyone's staring at him saying, "Well, we don't know a Bob."
Right.
And this literally is 4 months after our wedding.
Right.
We know a Robert and Kelly.
Right.
We don't. So what I'm thinking is, what happens in the case of text when there are synonyms or there is something similar, and you're a lawyer and you're searching? What's the duty the lawyer is going to have when you start searching databases and things for law? What if you don't understand the similarity between Bob and Robert and they're called the same thing in a legal context?
Right. I guess that's what I was sort of getting at with the idea of corpus selection, because a Robert and Bob may not be known in a particular domain, but it may be very well known in a different domain. And so I think part of where this shifts is that right now we can sort of chalk this up to say, well, these are hard problems, but in fact, what we might see in the coming years is that, well, let me take a step back. This topic, like the change in natural language processing and corpus selection, is the thing that is like being focused on right now. So Google came up with this thing called BERT a couple of years ago that like changes the game, and things that were theoretically possible are now everyone's doing it. And so corpus selection, doing sort of advanced natural language processing, and coming up with sort of these similarities in this thing called word embeddings, and is now a thing. And so long story short, I don't know what our obligations are as lawyers to sort of understand that, but I'm pretty confident that as this becomes more prevalent, that companies are going to have to adapt and create features that are going to make it more likely to say, oh, you know what, this has that similarity, or at least did you mean this type of thing may become more common?
Yeah, and it's not just synonyms, but often the exact word is the problem too. So you take something like the Code of Federal Regulations, an obscenely large document with a whole large number of definition sections that relate to subsections. So you will have, a particular word defined or a particular phrase defined differently multiple times through the entire thing. So understanding the architecture, not just the corpus, but the architecture of where you are, the context of where you are. So a lot of the tools rely not just on understanding of the words, but understanding of the relationships. So something might be a concept, and the concept might have a relationship with an entity, which has a relationship with a document, and so on and so on. So the tools that are being developed have to be accountable or aware of and address those things as well.
Any other questions? So let me ask, since we're almost at the end, let me ask the kind of almost science fiction-y question about the analysis of legislative texts. And I have my own instinct about what the answer to this is, but I'll throw it out. And let me frame it by, again, using a basic conundrum that will be familiar to students who have taken legislation, regulation, or anything similar. And it's this. We worry that judges, when called on to interpret statutory texts, will be unduly influenced, perhaps subconsciously, by what they would like the text to say. Not everybody worries about this. Some people actually enthusiastically embrace the idea that judges may act as junior partners with the legislature and bring their own understanding of wise policy and so forth. So great legal thinkers like Guido Calabresi and Ronald Dworkin and Richard Posner have adopted something like that view. But many people subscribe to the view that in the context of statutory interpretation, the legislature is the master, the judge is the servant, the faithful agent, and that it is a problem that judges may be influenced by their policy preferences. Mm-hmm. And I could imagine a real technological enthusiast imagining a world where the technology would get good enough, the language processing would get good enough, the ability to draw on contextual materials would get good enough, that there would be some kind of objective metric of what the legislature more likely meant when it used this language that, in a real fantasy world could replace judges, or at the very least could generate, objective information that judges, if they want to deviate from it, will be very difficult for them to do it. Others might hear, no one thinks this could be done now. Some might think, well, actually, all sorts of things we have today that were unthinkable 100 years ago, that like 100 years ago, 100 years from now or less, this might actually be possible, and the dream of objective statutory interpretation of faithful agency is realizable. Others might think of this and say, no matter how good your computer technology gets, you will never be able to do this, even if you would like that to be the goal. There will always need to be a human judge, a human intelligence engaged in an act of judgment, and the fact that they may allow their policy views, that they may at some level influence them, that's just the price we have to pay for having a sensible approach to interpretation. So I want to, again, this is a little bit unfair, but I'm asking you to, we're talking about law and technology, and people like to imagine the future. So is that an imaginable future where at least the faithful agent version of statutory interpretation could be done and made objective through a sufficiently sophisticated computer system? Or is that just, do you think that's just sort of a fundamentally impossible thing? And again, I take your point about forecasting. I mean, everyone cites the Yogi Berra cliche about how prediction is hard, especially when it's about the future.
Right.
But I mean, again, maybe we would have closed this out to take some of this and to ask one of these really big fundamental questions: is can technology solve what many people would view as the most fundamental or one of the most fundamental problems in statutory interpretation?
Do you want to take a crack first?
Sure. I'd say first, if that were conceived as possible and desirable, we would be seeing a lot more activity in civil law jurisdictions heading in that direction, and I don't think we are. In fact, there's a company in France called Doctrine, and they did an analysis of the length of decisions. And civil jurisdiction, they should not have long decisions. But year over year, the decisions are getting longer and longer and longer. So you have this introduction of interpretation in a jurisdiction where it's not there, and that's going to wind up messing with the information. The other piece is on the NLP itself. So there's an annual competition that's run through the University of Alberta, and I can't remember the institution in Japan, that's called the Competition on Legal Information Extraction and Entailment. So the banner headline a couple of years ago was "Computer passes a Japanese bar exam," and there it was a lot of yes/no questions relating to a particular statute. But that group of legal AI NLP focused scientists for the past couple of years have been adding case law in because they can't learn enough from just analyzing statutes. So I think ultimately my answer is going to be no, because I don't see an institutional push in the direction of either from the authors of law or the people working on NLP specifically in law in this area to say that that's the end goal.
I'm going to give a qualifying yes. I think the reason that I say it's a qualified yes is that I think what we consider to be a hard case today will actually be a relatively easy case in the future. There will be new hard cases. And I think that, particularly as certain, there may be disputes over property and disputes over tort that right now are really complicated, and just in the future it's like, no, that's a knowable fact given other contexts, and some things like natural language processing, these may be knowable facts. So I think what is presented to a court may shift over time. That said, I think as long as there are humans involved either in the policy-making process or in the actual, interacting with each other in real lives, as long as there's interaction, there's going to be inherent ambiguity and questions about equity. And to the extent that there's questions about equity, I don't think that a computer can solve it.
Well, I think that's a terrific note on which to end. Thanks to both of you, Colin, Dave, for that really interesting presentation. It certainly gives me a lot to think about as I continue to try to teach this material as a non-tech guy to what's certainly going to be a tech generation. So thank you very much. Thank you to Robert and the other organizers for organizing the panel, and thanks to all of you for being part of it. And that brings us to a conclusion.